Okay, so today we're going to look at mortgages. We've been talking about different property law transactions. We have looked at power. Well, we have looked at donation of power, sale of land, leases, and so forth. And now we're talking about mortgages. You understand? So it could be that a person doesn't want to sell his property. You understand? He doesn't want to part with it permanently. It could also be that a person doesn't want to. He doesn't want to grant a term of years. You understand? He doesn't want to start taking rent yearly or whatever, and he doesn't want to sell the property. You understand? So he's in a situation whereby he wants money urgently. You understand? He wants money urgently. He cannot wait for all those stages of a sale of land or waiting for yearly to take his rent and all. So he wants the money urgent because he wants to carry out a business or something. So the best option for him now will be a mortgage. You understand? And a mortgage is a contractual arrangement, is a security interest transaction. You can just say it's a contractual arrangement where someone transfers the legal title over his property in exchange for loan. You understand? Subject to reconveyance upon discharge of the loan or upon discharge of the mortgage. Now, the implication of this definition is that immediately a person pays back that money he borrowed, he's entitled to have the property conveyed back to him. And the parties to a mortgage transaction, are the mortgagor. You understand? That is the borrower, the person who is taking the loan and using his property as a collateral or a security for the loan. And then we have the mortgagee. The mortgagee is the lender, which is usually a bank. You understand? Most people prefer to go to banks, even if we have mortgage institutions and other bodies that can give mortgage for every time they are going to banks. And then another party that could be in a mortgage transaction is the third parties. You understand? There's something called tripartite deed of mortgage. So it's possible to have someone taking a loan and then the bank is requesting for a surety or a guarantor. So in that case now you will have a third party, you understand, who is going to stand as a guarantor in respect of the mortgage transaction. And then there are certain transactions that are similar to a mortgage, but they're not a mortgage. For instance, there's something called pledge. You understand? The major distinction between a pledge and a mortgage is that a pledge involves you giving out possession of your land in exchange for loan. You understand? So, but in mortgage, you don't give out possession. What you give is legal title. You, the mortgagor, continue to be in possession of your land. You understand? But you just give out the legal title. As for that particular time, legal title has passed from you to the bank. You understand? But in pledge, you're not giving legal title. You're rather giving possession. And pledge is often used in a local setting, villages. That's why some authors will refer to pledge as customary mortgage. You understand? Although that's a little bit wrong. And they will have lien. You understand? Now, lien is when somebody has a lien on your property. You understand? It means that he's detaining your property. Your property is in detention. He detains the property until you pay the requisite amount of money, to discharge whatever loan he gave to you, and then he releases your property to you. That is what we call lien. And then there's something called charge. Now, when a person charges his property for a loan, that particular property has been appropriated. It means that property has been set aside. You understand? That property has been set aside. It is now encumbered. Someone can have about 4 properties, and then he will decide and say, look, this money I want to borrow from you, please, I want this money from you. Look at my property here, my black acre at number 45 Ozumbambadiwe Avenue. He has about 4 properties, but he just brought out that particular one, that in case I don't pay back the money, use this particular property at Ozumbambadiwe to recover your money. You understand? So that particular property has been set aside. That is what we call appropriation. It has been set aside for the discharge of the loan, in case of necessity. And then at the same time now, it is now encumbered. It has encumbrances on it. You understand? So that's what we call a charge. And then a sale. Everybody knows what is a sale of land. You transfer ownership, unexpired residue from the assigner to the assignee. And then solicitors. Solicitors have roles to play in mortgage transaction. For instance, they draft the mortgage documents, the loan agreement, the deed of mortgage. They advise the parties on the transactions, the enforcement and all that. they prepare search reports, they carry out investigations and all. So solicitors has a lot of responsibilities in mortgage transactions, even the perfection. They have to take steps to make sure that the mortgage deed is registered, is stamped, and all that is part of their job. And then just like every transactions, there are general applicable laws and there are also specific applicable laws, you understand? Depending on, I believe you didn't forget what I said earlier, when it has to do with the specific applicable laws, you're looking at the status of the parties, the location of the property, and so on and so forth. And then we have mortgage institutions, or you can still say the sources of mortgage loans. In other words, where can you get mortgage loans from? Nobody, I don't think anybody in exam will come and be asking you mortgage institutions in Nigeria, you understand? But it's something you should just know, you understand? So anybody who is in need of loan can go to the mortgage, can go to the Federal Mortgage Bank. That's like the number one mortgage institution in Nigeria. You understand? So it actually gives, I think it's very advantageous in terms of giving loans because, for instance, for individuals like me and you, it's just about 6% interest, just about 6% interest, and then repayment period is spread across 20 years. You get, so it's very much easier. It's very much easier, and very much less cumbersome compared to other mortgage institutions. We also have housing corporations. They can also give loans. You understand? They can also build houses and then sell it to people at procedural rates, like gradually you pay and all. We also have employers housing schemes. You understand? So employers can also create housing schemes for employees, providing loans for employees, secured by the property. And then we also have commercial banks. Now, banks like UBA, First Bank, they all have mortgage branches or mortgage institutions inside of them. So they can grant you loan as well. But one problem about these banks is that the loan they give are often very high. You understand? The interest rates are often very high and they're quite cumbersome. And then we have private property developers. Today we have a lot of real estate moguls and real estate tycoons. Understand? So some people might build houses, completely, and then they allow people to enter there and start paying, piecemeal, bit by bit, bit by bit. They spread the payment across maybe 2 or 3 years and all. And then life endowment. People can use their life insurance policy as well as a security for loan. Understand? So like I said before, nobody is going to be asking you mortgage institutions in Nigeria, but it's just have an idea. And then we have stages in the mortgage transaction. These stages is not like it may differ depending on the location of the parties or the circumstances involved. So this is not like a specific stages or something, but you can just take it as the general stages in a mortgage transaction. So anybody who wants a loan will definitely apply for the loan, and he's going to negotiate the loan as well. And then there will be preliminary investigations. Understand? There will be preliminary investigation. For instance, the bank is not just going to give you a loan. It will bring a document of title, your good root of title, to show that yes, the land is your own. They might even carry out physical inspections on the land and all, just to make sure that yes, you are, just in a way, mortgage is almost similar to sale of land in a way, because you are giving legal title over that land. You understand? What you just have is the right of redemption. You understand? What you just have is the right of redemption. Most times, you're giving legal title, and what is remaining is your right of redemption. You understand? So mortgage is almost similar to a sale of land. So it is also proper that the bank will have to conduct investigations and all to make sure that you are the owner of the property. And then valuation, they are going to value the property and all, documentation. That is drafting the deed of mortgage and execution, and then perfection of a title. That is consent, stamping, and registration. And then in the course of for instance now, if for instance a bank wants to give a businessman loan, maybe a loan of 100 million, one of the ways a bank will investigate is by engaging a lawyer, right? The lawyer is going to The lawyer is going to investigate on their behalf. You understand? The lawyer will go to land registry to ascertain if really the mortgagor is the owner of the property. You understand? And then the lawyer will not just come back and tell the bank that look, this is it, this is that. He's going to prepare what we call a search report. You understand? He's going to prepare what we call a search report. So it is in that search report that the bank is now going to look and then decide for themselves if they're really going to give the mortgagor the loan in question. So a good search report must contain the date of search, the place the search was conducted, the name of the solicitor that conducted the search, the person who owns the property, if it's different from the borrower, description of the property, nature of interest, any encumbrances, and then the solicitor's recommendation, signature of the solicitor or no. So it is possible that the solicitor, in the course of investigating the title of the property, found out that the property is jointly owned, or maybe the mortgagor is not really the owner of the property, or the mortgagor does not have a good root of title. And then he will recommend to the bank that they should not give the loan to the mortgagor, otherwise, they might run into legal troubles. So in that case, now the bank is going to refuse. So a good search reports are very, very important. They form part of the foundations. They form the foundations as per the decision of the bank. We don't know they're going to give a loan. And then where the mortgagor is a company, you understand? It is possible now that a company might want to borrow from a bank. A company can borrow from a bank. A company can borrow from mortgage institution. A company can borrow from the Federal Mortgage Bank of Nigeria. You understand? So if, for instance, a bank which a company wants to borrow from has actually engaged a solicitor to conduct an investigation on that company. You understand? So if you look at the content of the search report, it's going to contain like the name of the company, the date of incorporation. Now, the essence of the investigation now will be this company that wants to come and borrow money from us. We are UBA or we are First Bank. And then this company, they said they are so Nigerian Limited. They want to come and borrow 1 billion from us, So the solicitor is now going to investigate, are this company really incorporated in Nigeria? Is it a sham or is it a real company? Have they filed their annual returns? Are they in default of any necessary document to be filed to the Corporate Affairs Commission? Are they operating within the bounds of law in Nigeria? So let's know who we are giving our money to. Understand? Let's know who we are giving our money to. And then I will look at the factors. What are the factors that might affect the validity of a mortgage transaction? Now, if a mortgage transaction wants to be entered, what are some factors that may affect its validity? One of them is capacity of the parties. Property law deals with capacity oftentimes. Not everybody can deal on land. You understand? That is why the question of capacity is always arising. Not everybody can deal on land. For instance, like we did in power of attorney, people who are insane, undischarged, bankrupt, and all. In a way, it also applies in mortgage. So a person of unsound mind cannot take a loan. He can't go and be taking a loan. An undischarged bankrupt, a company in liquidation. This set of people cannot be a party to a mortgage transaction. And then infants as well, depending on the jurisdiction. In Conveyancing Act states, infants cannot be a party to a mortgage transaction. Any loan given to that infant is void. You understand? The money cannot be recovered. But in PCL states, that is a property and conveyancing law states, the transaction is only voidable. You understand? The infant holds the money in trust. You understand? So the transaction is not void in PCL state. It's only voidable. And the infant holds that money in trust. So it cannot be said that the money is not irrecoverable. The money can still be recovered from the infant. Maybe when he attains majority. I don't know. But you know that the position of law here is different from that of the Conveyancing Act, which makes it void and irrecoverable. And then the mortgagor's title. What if the person that wants to take the loan and is telling you that he's using so land as security or collateral, but he's not really the owner of the property? What happens? You understand? So now in that case, now the mortgage is not void. In that case, the mortgage is not void, but it becomes unsecured. It becomes unsecured because there is no real collateral offered. So the mortgage becomes unsecured. And then that debt now becomes recoverable as money had and received. What we mean money had and received, it is like normal normal action for recovery of debt. You understand? So the bank is going to sue the guy now, no longer as a mortgagee and mortgagor, but rather as a debtor and creditor. You understand? That's what we mean. And then proper documentation and attestation. So a mortgage transaction must be properly documented, and there should be proper attestation. For instance, in the case of an illiterate person, if the mortgagor is an illiterate, for instance, a jurat ought to be used, because it is a deed of legal mortgage. So a jurat ought to be used, explaining the nature and content of what he's signing, you know, so that he won't come tomorrow to say, oh, he didn't really know he's going to pay this huge amount of money, that the interest is too much or whatever. So an illiterate jurat should be used. And another one is stamping. The mortgage document should be stamped as well, as required by law. And then consent of the governor should be obtained. If consent of the governor is not obtained, that mortgage transaction is of no effect. You understand? The mortgage transaction is of no effect, because by section 22 and 26 of the Land Use Act, whenever you want to pass any interest in land, you must seek the governor's consent. You must seek the governor's consent. And then what are the forms of mortgage transactions? Now, when we talk about the forms of mortgage transaction, a mortgage transaction could be that the mortgagor uses his own property as a collateral for the loan. This is one form. The mortgagor, who is a borrower, can use his own property as collateral for the loan. And then the mortgagor can also use the property of another person for a loan. You understand? Maybe the property of a relative as a security for the loan. And then it could also be that the property that is intended to be used as collateral, it is to be purchased. It has not yet been purchased. It is to be purchased. So imagine when somebody wants to acquire loan, at the same time he wants to buy a property in order to use that property as a security for the loan. You understand? And then example. So this is what we call, this last one now, where someone wants to get a loan and then he's using a property that is going to be purchased as security for the loan. This will usually arise in situations whereby, for instance, the bank wants to give him the loan. Yes, the bank wants to give him the loan, but they just want something. Let it just be that he has a collateral. Let there just be a collateral. There's something the bank can hold on to. And then he decides to buy a property. He decides to buy a property to be used as a security for the loan. Now, this is a little bit complex, because somebody is buying a property in order to use that property as security for the loan, and then him buying the property is dependent on the loan being granted. For instance, in the contract of sale, he will usually tell the person, look, if the loan is not granted, any part payment that has been made is going to be returned, and I will not be bound again by the contract. That is how this scenario usually looks. Understand? And this is what we call contract of sale subject to mortgage. You understand? In my own view, I believe it usually arise when maybe the bank already is willing to give him the loan, but they just want something. They just want a collateral. They just want a collateral from him. Understand? They just want a collateral from him. So he has to purchase a property in order to use the property as a loan. Understand? In order to use the property as a loan. Or maybe the person wants to raise money. Maybe the mortgagor wants to raise money, and the available assets he has is not enough to raise that money. And then another thing we have to look at is the types of mortgages. Types of mortgages. Now we mainly have I think we mainly have two types of we have about two types of mortgages. We have legal mortgages and we have equitable mortgages. We have legal mortgages and we have equitable mortgages. Now, the essence of a legal mortgage is that legal title passes. When a legal mortgage is created, the mortgagor transfers his legal title over the property. You understand? He will usually give his document of title, everything in relation to that property, to the mortgagee. You understand? So oftentimes what the mortgagor just have is that he's just residing in the property. He doesn't give up possession most times. Although the mortgagee can still come at any time to say he wants to take possession of the property. He understand it happens. But a legal mortgage, like I said before, the mortgagor transfers his legal title in exchange for the loan, but then subject to reconveyance upon redemption, meaning that if he discharges the loan or if he liquidates the loan, that is paying the money that he's owing, they will have to transfer back the legal title to him. They will transfer back the documents of title, all the deeds and all that you have in relation to that property will be transferred back to him. So a legal mortgage is usually made by deed, you understand? It's usually made by deed, is usually perfected, you understand? Consent is obtained, is stamped, is registered, is duly perfected, you understand? Is of more legal validity, complies with the law. Legal interest passes. Legal interest passes from the mortgagor to the mortgagee. And is advantageous because it is easily enforceable. For the mortgagee, for instance, he can easily enforce the mortgage. If the mortgagor doesn't want to pay back the money, it's simple. You have legal title over the property. You have all the documents. You can just sell it. You understand? A deed of legal mortgage is a good route of title. You can just sell the property. You understand? So the mortgagee doesn't need to approach the courts before he can sell the property. Yes, he doesn't need to approach the court. In the case of a legal mortgage, he doesn't need to approach the court. If the due date has passed, maybe the mortgagor was supposed to redeem his property on the 10th of August, and it's already 15th of August. The mortgagee, you don't need to go to court and start telling the court, look, I want to sell. You can just sell the property because the legal deed, so it's easily enforceable. And it usually has priority over equitable mortgage. Understand? It's not susceptible to fraud as well. And then it's a good route of title, like I said before. And then we have what we call equitable mortgage. Now, in the case of equitable mortgages transfer only equitable interest. No legal interest passes. You understand? So in the case of equitable mortgage, you can say that the mortgagor remains the title holder. You understand? He still has title over that property. Understand? He still has title over that property. So in the case of equitable mortgage, you can say that the mortgagor still has title over that property. You understand? Legal title does not pass. The legal title still remains on the person of the mortgagor. And then equitable mortgages, usually, although there are exceptions, but usually it is not made by deed. You understand? Equitable mortgages usually are not made by deed. They are usually just in writing, you understand? And then it doesn't pass any legal interest. Only equitable interest passes. Only equitable interest passes from the mortgagor to the mortgagee, you understand? In exchange for loan, subject to reconveyance upon redemption as well. So equitable mortgages are also, it has its own advantages. For instance, it is used mainly for small amounts of money. Maybe somebody is in need of 600,000. You understand? There's no need to be executing a deed of assignment, waiting for governor's consent, stamping, registration. You can just give him the 600,000 and have an equitable mortgage over his property. Is less cumbersome. An equitable mortgage is less cumbersome. It's cheaper. An equitable mortgage is cheaper. It's less cumbersome, and I know. So what we should go into now is how do we enforce equitable mortgages? Understand? How are equitable mortgages enforced? Understand? So when we talk about enforcement, we are talking about how does an equitable mortgagee get back his money? Understand? How does he get back his money? So in an equitable mortgage, whenever the mortgagor defaults, the mortgagee in an equitable mortgage does not have the power of automatic sale. You understand? He doesn't have this power of automatic sale. He cannot just immediately sell the property and recover back his money. You understand? That is usually the right of a legal mortgagee. You understand? That is usually the right of a legal mortgagee. So ordinarily, an equitable mortgagee will have to apply to what we call a foreclosure. You understand? His major remedy is a foreclosure. Where the court will have to give some time where the court will have to give some time to the mortgagor to redeem his property. And then I think after 6 months or so, if he doesn't if he doesn't do what is necessary, like if he doesn't pay back the money within that time period given 6 months or so, if he doesn't pay back the money, you understand, and then that foreclosure becomes what we call absolute, you understand. So for that time, it is open for him to pay the money. It is called a foreclosure order nisi. But then when it becomes absolute, in that case now, he has lost the opportunity to redeem that property. So that is a remedy of an equitable mortgagee. You understand? He cannot sell the property. That is a remedy of an equitable mortgagee. But then, if you want to exercise the right of sale, if he wants to exercise the right of sale, he must, as a matter of condition, approach the court. He has to approach the court. If an equitable mortgagee wants to exercise the right of sale, he must approach the court. You understand? He's not going to say, oh, this person has defaulted. The legal due date has passed. He's supposed to pay by 10th of so day, but he didn't pay, so I will sell it. No, he must approach the court. You understand? He must approach the courts, because ordinarily he does not have the right to sell the property. But then now there is an exception. There's an exception when an equitable mortgagee. There is an exception when a mortgagee in an equitable mortgage, or when an equitable mortgagee may sell the property without recourse to the court. You understand? That is, without approaching the court, he can sell the property. So that is when the equitable mortgage was created by deed. When the equitable mortgage was created by deed, when the legal due date has passed, when either of the remedial devices is inserted, and there is no contrary intention in the deed as to the power of sale. You understand? So, like I said before, generally equitable mortgages are not made by deed. You understand? But then sometimes, as a matter of exception, there are some equitable mortgages where the parties will agree that it should be made by deed. I think that will be usually the suggestion of the mortgagee. You understand? See, even if it's an equitable mortgage, please let's make it by deed. Let it be under seal and so forth. So where it is made by deed and the legal due date has passed, and then there's what we call remedial devices. You understand? So because the equitable mortgagee does not have the automatic power of sale, a remedial device may be inserted in the mortgage agreement. An example of a remedial device is a power of attorney. You understand? So in the mortgage agreement, they can put what they call a power of attorney clause. Now, the essence of that clause now is that as that equitable mortgage is created, you understand, as that equitable mortgage is created, that the essence of this clause is that as the equitable mortgage is created, the mortgagor is also at the same time giving an irrevocable power of attorney over that his property to the mortgagee. You understand? I'm just giving you an example. That's what we call a remedial device. There are two remedial devices. We have the trust declaration and we have the power of attorney clause. You understand? So when, for instance, the bank says let's insert a remedial device, and that remedial device you are going to insert is the power of attorney. You understand? So the essence of that remedial device is that as this equitable mortgage is created, you are also giving us, the bank, an irrevocable power of attorney over this your land. You understand? So the implication now is that if you don't pay, you understand? So when they have an irrevocable power of attorney over your land, what does it mean? It means that they can do whatever they want with it. You understand? So if all these things are in existence, then an equitable mortgagee can then go ahead to sell the property, where there is a default on the part of the mortgagor without applying to the court. So what are the modes of creating an equitable mortgage? There are different modes of creating an equitable mortgage, and it will depend on the jurisdiction in question. So in creating an equitable mortgage, we have the modes in Conveyancing Act and PCL states combined. So you see, you can create an equitable mortgage by depositing your title deeds. You understand? That is by depositing your, for instance, deed of assignment and all relevant documents showing you are the owner of the property. You can deposit it with the bank. accompanied by a memorandum of deposit with the intention that the deed should serve as security for the loan. You understand? So somebody can just use his deed of assignment. Someone can use his title deed, his document of title. For instance, his deed of assignment, the deed of assignment he has over a land, he can just use it as a collateral for the loan. You understand? He can just use it as a collateral, and then they will give him loan. That's an equitable mortgage. And then a mortgage created by a person whose interest is only equitable. So where the mortgagor only has an equitable interest over that property, the mortgage created is an equitable mortgage. And then there's something called equitable charge. You understand? So a mortgage can also be created by way of an equitable charge. By way of an equitable charge. In that case, now the property is being appropriated and is being set aside. Is appropriated and is being set aside for the satisfaction of the loan being taken. That is what we call equitable charge. And then where parties wanted to create a legal mortgage, you understand? Where parties wanted to create a legal mortgage, but they did not succeed, you understand? Probably because whatever reason at all, they wanted to create a legal mortgage, but in the process, they failed to create a legal mortgage, So what they have there now is an inchoate legal mortgage. So an inchoate legal mortgage automatically translates to an equitable mortgage, you understand? And then another one is an agreement to create a legal mortgage without being in proper form under the rule in Walsh against Lonsdale, you understand? So where parties have the agreement to create a legal mortgage, under the rule in Walsh against Lonsdale, they say an agreement for this is as good as that thing. So an agreement to create a legal mortgage without being in proper form, creates an equitable mortgage. And then someone can also deposit his title deed with an agreement to create a legal mortgage. Someone can also deposit his title deed. He deposits his title deed, and then there's an agreement that a legal mortgage is going to be created. And then if we look at the position in Lagos, we see that it's slightly similar, you understand? So in Lagos, an equitable mortgage can also be created by deposits of title deed with an agreement to create a legal mortgage, you understand? So someone can also deposit his document of title, like his deed of assignment or whatever that proves ownership to the property. He can deposit it with the bank, and then that creates an equitable mortgage, you understand? Coupled with an agreement that yes, they're going to create a legal mortgage. And then assignment of an equitable interest, you understand? So a person can also create an equitable mortgage in Lagos by the assignment of an equitable interest, and then by charge of an equitable interest coupled by an agreement to create a legal mortgage. Understand? So whenever you hear this charge, someone is actually appropriating. You understand? A particular asset is set aside. That in the event that the money is going to be repaid back, use this property to repay back the money. So that particular property is appropriated, is set aside. You understand? The property is set aside. And then in Lagos, a person can have an equitable interest over a property, and then he will assign that equitable interest to the bank. That is one way to create an equitable mortgage as well. So in Lagos, for instance, where mortgagor refuses to execute a deed of legal mortgage, what happens? If you look at these modes of creating an equitable mortgage, you will notice that most of them are carrying is either deposit of title deed with an agreement. He is having an agreement, you understand? So it's more like parties are entering into an equitable mortgage, and then there's an agreement that they are going to convert it to a legal mortgage, you understand? So what if, for instance, the mortgagor refuses later on to execute a deed of legal mortgage and he's in Lagos? Now, the law is that in that particular case, where the mortgagor refuses to execute a legal mortgage, the mortgagee can file an originating summons in court to compel him to execute that legal mortgage within 1 month. And if he still refuses to execute it, then the court may authorize an officer to execute the deed on behalf of both parties. Now, I would like to explain this stuff. You understand? You might meet a bank now, or you might meet any institution or anybody for mortgage, and then you're telling the person that the money you want to take is not much. That is just 1 million, But the person will still be saying, no, I want it to be a legal mortgage. Why? Because he wants to easily enforce it. You understand? He say he wants it to be a legal mortgage, and it's mostly because he wants to easily enforce it. But then you're saying, okay, let's enter an equitable mortgage, and then don't worry, we are going to make it a legal mortgage. So you're entering that equitable mortgage with an agreement that you're going to make it a legal mortgage. You understand? So in that case, now, what if after taking that money, you don't want to now execute the deed of legal mortgage? So what's the person going to do? The proper thing he's going to do is to apply to court by way of originating summons. You understand? He's going to apply to court by way of originating summons, and then to compare you, the mortgagor, to execute a legal mortgage within 1 month. And if you refuse, then the court can authorize an officer to execute it on your behalf. You understand? On your behalf and on behalf of the other party. And then we look at the modes of creating legal mortgages. You understand? So in Conveyancing Act states there are about 3 ways you can create legal mortgages. You understand? You can create legal mortgage by assignment. But please, in exam, you just have to state the full, like, I think that they also ask this stuff sometimes, so you must state it in full, by assignment of the unexpired residue, subject to a proviso for CISA, for redemption. Now, the implication of this is that in Conveyancing Act states, when you create a legal mortgage by way of assignment, it is assumed that you're giving everything to the mortgagee. The mortgagor has given everything to the mortgagee. He has given not just his legal title, he has given his reversion. He doesn't have any reversionary interest again in that property. You understand? So the mode in which you create a legal mortgage has consequences. It has consequences, both positive consequences and negative consequences. You understand? So in Conveyancing Act, for instance, when a legal mortgage is created by assignment, that is why they say the assignment of the unexpired residue. So it's more like ownership. You're assigning your ownership to the mortgagee. You understand? Your reversion, everything. The only thing you have left is just a proviso. A proviso is there that whenever you discharge the loan, that they are going to convey it back to you. That is Caesar upon redemption. You understand? So that is the only thing you have left is just your right of redemption. For the ownership, legal title, reversion, everything has passed. It is of great consequences. It has advantages, it has disadvantages. For instance, now, in this case now, the legal mortgagee can sell whenever he defaults because the property is technically his own, no longer your own, the mortgagor. You understand? That's one of the advantages for the mortgagee. But then if you look at it from another angle, for the mortgagee, for instance, since unexpired residue has been assigned to him, it means that all these rates, all these taxes, whatever that is required to be paid in the land, he will not be the one to be paying it. For instance, ground rent, that people usually pay ground rent in their land to the governor. The mortgagee will start paying that ground rent. If there are any taxes, any levies at all that is payable on that land, the mortgagee will start paying it, understand, because reversion has passed to him. Again, so that is it. Another way you can create mortgage in CS states that you can create legal mortgages in CS states is by subdemise. You understand? Subdemise for a term of years, but at least less than 1 day than the term vested in the mortgage, or subject to Caesar upon redemption. Now, the first comment I want to make about this pattern is that in this pattern, you don't give your reversion. You understand? You transfer your legal title, but you still hold your reversion. You understand? You still hold your reversion. The reversionary interest still endures in the mortgagor. The mortgagor still has his reversionary interest. You understand? Although he has given legal title over the property to the mortgagee, but he still has his reversionary interest. That is why in this case now, like in CA state, in this case now, the mortgagee cannot sell the property. You understand? The mortgagee cannot sell it. Like, he doesn't have automatic power of sale. If he wants to have automatic power of sale, he should have gone by way of assignment, or if he's creating it by subdemise, he should insert what we call a remedial device. Just like we saw in equitable mortgages. But then, just like the one up here, even in the subdemise, there is still a provision for Caesar upon redemption. Understand? So when the loan is discharged, the property will go back to the mortgagor. And then the mortgage can also be created. A legal mortgage can also be created in CA state by way of I just prefer to call this by way of charge. Although in exam you have to write it in full by deed expressed to be by way of statutory mortgage with the proviso for the conveyance or repayment of the loan. But this is what we call creating a legal mortgage by charge. It is also known as statutory mortgage. You understand? It is also known as statutory mortgage. Now, when a legal mortgage is created by charge, you understand, it does not confer legal interest. Legal interest does not pass to the mortgagee. You understand? Legal interest does not pass to the mortgagee. Legal interest does not pass to the mortgagee. Unlike the first two that we saw in assignment and subdemise, legal interest does not pass to the mortgagee. But it's just that the mortgagee has a right of lien over that property. You understand? The mortgagee has a right of lien over that property. He has a right of lien over that property, so that if the other person, if the mortgagor doesn't pay the loan, if he doesn't pay back the loan, he can just seek to enforce the mortgage by a court order for sale, and then use the proceeds of the sale to discharge the lien or to discharge the loan, as the case may be. You might see the case of Ogundani against Araba. And then in PCL states, there are three ways you create a legal mortgage. It could be by subdemise. It could be by subdemise for a term of years absolute for at least less than 1 day than the term invested in the mortgagor. Or it could be by charge by deed expressed to be by way of legal mortgage, or charge by deed expressed to be by way of statutory mortgage. Now, the essence of it is technically the same. So in PCL states, you can create a mortgage by subdemise or by charge. It's as simple as that. Just say by subdemise or by charge. You understand? But then one thing I want you to know is that in PCL states, when you create like we did when we did creation of legal mortgage in CA state, we noticed that when you create a legal mortgage by assignment, you transfer both your reversion, your ownership, legal title, everything, and the other person and the mortgagee will now have automatic power of sale in cases of default. You can sell the property. While in subdemise, the person still retains his reversion, meaning that the mortgagee cannot sell the property if the mortgagor defaults in paying. But now in PCL states, if you look at the provisions of the PCL, Property and Conveyancing Law, I think section 123, I think it's section 123 or so, So it is provided in the statute for PCL that even if a mortgage is created by subdemise, you understand, even if the mortgagor still has his reversion or his reversionary interest, that the mortgagee will be entitled to automatic power of sale. So it is provided in the statute, you understand. So the PCL, Property and Conveyancing Law, provides that as a provision in the law. So even if the mortgage is created by subdemise and you say the mortgagor still has his reversion or reversionary interest, that the mortgagee will have automatic power of sale, you understand? Because there is no assignment, there's no provision for assignment in PCL. What they have is only by subdemise and by charge, you understand? So in their own subdemise now, the mortgagee has automatic power of sale if the mortgagor fails to pay the loan. And then we have the procedure in Lagos, like how we create legal mortgages in Lagos. It is also similar in some way. For instance, in Lagos, you can create legal mortgages by charge as well. Whether charge by deed, legal mortgage, charge by deed, statutory mortgage, charge is charge, understand? You can create legal mortgages in Lagos by charge. You can also create legal mortgages in Lagos by demise or by subdemise. Now, demise in Lagos has the effect of an assignment. You understand? Demise in Lagos has the effect of an assignment, while subdemise has the effect of a subdemise, like in other states or in other jurisdictions. Then we go to what we call successive legal mortgages. Successive legal mortgages. Now, successive legal mortgages refers to a situation where, for instance, someone uses his property, one property, you understand? He has a property at number 55 Ozumba Mbadiwe Avenue, and he uses it and takes a loan from First Bank. And then he wants another loan. He uses the same property and takes another loan from UBA, you understand? And then he takes the third loan from Paralex Bank, you understand? So 3 mortgages on one property. That is what we call successive legal mortgages, you understand? So now, is successive legal mortgages possible in all jurisdictions in property law? Is it possible in all jurisdictions? So we're going to find out. So now, in Conveyancing Act states, for CA states, if the mortgage is created by, if the legal mortgage, like the first legal mortgage was created by assignment, you understand, it's relevant to know that successive legal mortgage is not possible. Why? Because when you create a legal mortgage by assignment, remember you have given your reversionary interest. You're no longer the owner of that property. You've given your reversion. You don't have anything again in that property. So you cannot use the same property to go and take another loan from another bank. You understand? But if the loan is, if the first legal mortgage was created by way of subdemise, you still have your reversion. You understand? You still have your reversionary interest as the mortgagor. Then you can still use that same property to take loan from another bank again. In PCL states, successive legal mortgages is possible. You understand? It's possible where the first mortgage was created by way of a subdemise. You understand? So if in PCL states, if the first mortgage was created by subdemise, then successive legal mortgages is possible. So the implication is that if you create it by charge, it's not possible for you to do that. But if the first one was created by way of subdemise, it's possible for you to have successive legal mortgages. But the only condition is that the subsequent mortgagee, you understand? In successive legal mortgages, you have like 1, 2, 3 mortgages, for instance, 1, 2, 3 mortgagees, you understand? So where there is a first legal mortgagee and then successive legal mortgage is made, and then the person uses the same property and takes a loan from a second mortgagee, a second bank. Now that second mortgagee, his interest is subject to that of the first mortgagee, so he must wait for the first mortgagee to be settled before him. And then in Lagos State, successive legal mortgage is also possible. You understand? It's also possible. And then in Lagos State, the first legal mortgage does not have to be by subdemise. Remember, in PCL states, successive legal mortgages is possible, but the first legal mortgage must be by subdemise. But now Lagos is telling you that even if the first legal mortgage is not by subdemise, you can still have successive legal mortgages. You can still use the same property, to take loan from a different bank, and so on and so forth. But then it's relevant to know that before you can have successive legal mortgages, there are conditions that you must fulfill. There are conditions that you must fulfill. The mortgage must be by deed, for instance. The mortgage, the mortgage must be by deed. So ordinarily, I'm thinking of a legal mortgage. It has to be a legal mortgage. It must be by deed. And then if you look at the CA state and the PCL, you will notice that the first legal mortgage must have been created by way of subdemise as a matter of condition, although this does not apply to Lagos. And then the value of the property must be able to accommodate any subsequent legal mortgage to be created. If your property is worth 5 million naira and you have already used it to borrow money from First Bank, you borrowed 4 million. You want to use the same property to borrow 5 million from UBA. It's not going to be possible because the value of your property cannot carry that subsequent legal mortgage. You understand? The value of the property cannot carry that subsequent legal mortgage. And then you also see other conditions like the mortgages must be on the same property. That is why we call it successive. The mortgagor must be the same person, and then the mortgagees are different persons. And then we talk about the issue of automatic power of sale. Now, automatic power of sale is a right of the mortgagee. You understand? It's a right of the mortgagee without recourse to court. That is, whether the mortgagee can on his own sell the property if the legal due date has passed. That is, for instance, the mortgagor is supposed to redeem his property on the 10th of August 2025. It was agreed that that is when the loan will be paid back. But then the loan is not paid that time. Now, can the mortgagee sell the property automatically without going to the courts? That is what we call automatic power of sale. You understand? So in the CA state, for instance, that is in the Conveyancing Act state, if that first mortgage was created, if that first mortgage was created, if that first mortgage was created by assignment, if that first legal mortgage was created by assignment, we know that the mortgagor has given everything to the mortgagee: ownership, legal title, reversion, everything. So the mortgagee can sell it automatically if the mortgagor defaults in paying the loan on the legal due date. You understand? And then, but if the first legal mortgage was created by subdemise, we know that the mortgagee in CA state does not have automatic power of sale. You understand? He doesn't have automatic power of sale unless he added one of the remedial devices. For instance, a power of attorney. That when the mortgage was created, at the same time, the mortgagor was giving to the mortgagee an irrevocable power of attorney over the land. You understand? So where there's a remedial device, then the mortgagee in CA state, where it is created by subdemise, can now sell without going to court. In the absence of that, the mortgagee cannot. In PCL states and in Lagos, automatic power of sale exists. The mortgagee at all times have automatic power of sale. And then we talk about the perfection of mortgage. So now, how do we perfect a mortgage? You understand? Where parties have entered into a mortgage transaction, and it's time for perfection. We know what perfection follows. CSR. Consent of the governor must be obtained. It's very, very important. Consent of the governor must be obtained. It must be the governor, not any inappropriate authority. Otherwise, such consent is invalid. And then the document should be stamped, of course. And then registration should be made at the land registry within 60 days of execution. Now, in perfecting a mortgage, it doesn't end there. In deed of assignment, it's just these three things you have and it's okay. But in mortgage, you go further. You go further in the sense that in mortgage, you say that if the mortgagor is a company, you understand? So if the person borrowing the money is a company, so land registry registration does not end there. You still have to register that particular mortgage with the Corporate Affairs Commission as a charge against the company. It's part of the perfection. That mortgage has to be registered as a charge against the company. As a charge against the company. And then if the property is in Lagos State, you understand? If the property is in Lagos State, a copy of the mortgage deed, must be registered with the Mortgage Board of Lagos State. So the Lagos State has a mortgage board where every copy of the deed of mortgage must be registered with them. So you see that in perfecting a mortgage, we are getting to about 5 steps, depending on the status of the party and the location of the property. And then if you want to obtain the governor's consent for a mortgage, what documents do you need? Stuffs like these are very examinable. They can tell you to list like 5 documents you need to obtain the governor's consent in a mortgage. So these are the documents you need: tax clearance certificate, the deed of mortgage, application for consent, the covering letter, title documents, evidence of payment of ground rent and other rates and taxes in the property, and so forth. If the mortgagor is a company, you also need a copy of the memo and articles of the company. You need a copy of the resolution of the board of directors in relation to that mortgage, and then a copy of the certificate of incorporation of the company. And then there are instances in a mortgage transaction where the governor's consent is unnecessary. There are instances where parties are entering into a mortgage transaction, but the governor's consent is not necessary. Understand? One of them is when you are converting an equitable mortgage to a legal mortgage, where consent was first obtained, then you don't need to get another consent. Some people might be creating an equitable mortgage, and then the equitable mortgage is made by deed, and they will seek the governor's consent, in creating that equitable mortgage. So if, for instance, they want to convert that equitable mortgage to a legal mortgage, they don't need to seek the governor's consent again. And then if for instance a mortgage has been created, and then now the mortgagee wants to reconvey back the mortgage property to the mortgagor, you understand, he doesn't need the governor's consent to reconvey that property back to the mortgagor after the mortgagor has paid the loan, you understand, provided the governor's consent was obtained at first when the mortgage was being created. And then there's something called upstamping of a legal mortgage. In upstamping of a legal mortgage, you don't need the governor's consent again. You understand? You don't need the governor's consent. Now, upstamping is where, for instance, Okafor takes a loan from UBA. You understand? Okafor takes a loan from UBA and he uses his property at number 55 Ozumba Badewe Avenue as a collateral or security for the loan. And the loan is probably 5 million. And then later on, Okafor goes back to UBA and say he needs additional 2 million on the same property. He's not bringing another property. He's using that same property he used to take 5 million. He's telling UBA to increase the loan for him. They should please grant him additional 2 million. Understand? If UBA grants him additional 2 million, Okafor will have to take that deed of mortgage and stamp it again. Understand? They will have to stamp it again. That is what we call upstamping. They will have to stamp that deed of mortgage again to reflect the value, of the transaction. They will have to stamp it again and reflect the value of the transaction. Oftentimes stamp duties are paid what we call ad valorem. That is based on the value of the transaction, the monetary value of the transaction. They will divide it, and then you pay some percent, 6%, 2%, 3% of the total price, whatever they will charge you. You understand? So in the case of upstamping, you don't need the governor's consent again. And then when you are creating an equitable mortgage, you ordinarily, when people are creating equitable mortgage, generally, equitable mortgages are usually not made by deed, you understand? And no legal interest passes in an equitable mortgage. So the governor's consent is usually not necessary. And then where it is merely a charge, you understand? A charge by deed, that is creation of mortgage by way of charge, you understand? A charge as well does not pass any legal interest. A charge does not pass a legal interest. It only appropriates and encumbers the property, creating a lien on that property. So in that case, no legal interest passes to the mortgagee, you understand? In a charge, no legal interest passes to the mortgagee. The mortgagee only will have what we call a right of lien. The property is encumbered in his favor. And then there are some taxes that are applicable. There are some taxes that are applicable in a mortgage transaction. Some taxes include consent fees, stamp duty, registration fee, personal income tax, company's income tax, if a company is involved, ground rent, which, because you must definitely show evidence of payment of ground rent if you want to obtain the governor's consent. Development levy can be paid as well. But capital gains tax does not apply. Capital gains tax does not apply in a mortgage transaction because the property is not being sold. And then we look at covenants in a mortgage transaction. We look at covenants in a mortgage transaction. So just like we had in lease, you understand? Just like we had in lease, we also have covenants in a mortgage transaction. They're more like the terms and conditions. You understand? So we have covenant to repay the principal sum and interest. You understand? So it is going to be stated clearly in the mortgage, deed that Mr. Mortgagor, this is when you pay the principal sum and interest. You understand? Borrowed. They usually state the date, which they usually call the legal due date. You understand? It is usually agreed by the parties, the legal due date. But if the legal due date is not stated by the parties, then the loan is going to be paid on demand. You understand? It's going to be paid on demand. But stating the legal due date is very important, so that the mortgagee can know when he's going to bring an action against the mortgagor, or for him to know when he can just sell the property. And then there's something called the interest clause. There's something called the interest clause. Oftentimes, some mortgagees can decide to draft their interest clause positively or negatively. Someone can say, look, the interest you're paying per annum is 15%. You understand? And you're required to pay. You're required to pay. Before the legal due date. But then they'll say something like, the interest is 15%, but if paid before August 25th, 2024, it shall be 10%. So in that case, now the interest you're going to pay, is positive, like is drafted in a positive manner. If you pay on time, they reduce it. But in a negative manner, if you pay late, they will increase it. They will increase it. So that is how interest, that is how the interest rate in a mortgage transaction can be couched. It depends on the mindset of the mortgagee. If the mortgagee is a wicked person, he will go with the negative one. Although the court will usually hold against interest clauses that appear like a penalty. You understand? And then we also have covenant to insure the property. So just like in lease, understand, parties can also decide who's going to insure. But the position of the law is that if the mortgage is made by deed, you understand, the mortgagee insures, but then he would then charge the amount of money he spent on the insurance on the property, you understand, so that the mortgagor can pay it. You understand? So if the mortgage is made by deed, the mortgagee will insure, but then that amount of money that he insured, he's going to add it in the property, so that if the mortgagor was supposed to pay 10 million to redeem his property, he will now pay 10.5 million because of the insurance that was carried out by the mortgagee. Understand? But then there are some times when the mortgagee need not insure. There are some times when his power to insure will be restricted, even if the mortgage is made by deed. That is where, for instance, the deed states clearly that there is no requirement to insure. Maybe parties in drafting their deed of mortgage stated clearly that there will be no need to insure. You understand? Or maybe the mortgagor has already insured the property. Understand? So before using the property as a collateral or security, the mortgagor already insured the property. Or maybe the deed is silent. The deed is silent as to insurance, and the mortgagor has taken out insurance with the mortgagee's consent. So in that case, the mortgagee does not need to insure again. So just like in a lease, covenant to insure here will also state similar thing: who to insure, risks to insure again, insurance company, and so forth. And then remedial devices. There are also covenants that may be inserted in a mortgage. I told you something. Remedial devices are important. They're important for equitable mortgages, and they are also important for legal mortgages created by or subdivided in CA states. You understand? One major importance is that it helps the mortgagees in those two instances to have a right of sale, to have automatic right of sale without recourse to courts. Because one of the examples is that, an irrevocable power of attorney is automatically created in favor of the mortgagee, while the mortgage is created as well, enabling him to deal with the property in whichever way he likes without interference from the mortgagor. And then we have covenants not to create leases and subleases on the property. Understand? So a mortgagor, for instance, if you have mortgaged your property, you're not supposed to rent the same property out. It's not possible. Understand? If you have mortgaged your property, you're giving legal title over that property to the mortgagee. So you can't be creating leases or subleases on the same property. You understand? If you want to do that, you must seek the consent of the mortgagee. You must seek the consent of the mortgagee before you have to do that. Unless maybe when you people were creating the mortgage agreement, such was allowed. But it's relevant to note that if the mortgagor already had tenants, if the mortgagor already created leases on the property before he used the property as a collateral, the mortgagee does not have any choice, He won't come now and say all the tenants should leave. No, he doesn't have any choice. He has to be bound by that. He has to be bound by that particular leases that was created before he obtained legal title over the property. And then conversely, a mortgagee, if for instance he goes into possession, a mortgagee who has gotten legal title over the property, if for instance he goes into possession, he may create leases. If he wants, he can rent out some part of the premises, without even the consent of the mortgagor. But the law is that he must account for any rent he received. You understand? So any rent he receives, he has to account for it so that the mortgagor can add it up with any money he has and use it to discharge the loan and get back his property. And then we also have covenant to repair as well in a mortgage. You understand? So they say the mortgagor usually repairs. In the mortgage transaction, the mortgagor usually repairs. But then if he fails to do so, the mortgagee can decide to repair. And then as usual, we charge it into we charge it into the mortgage loan. You understand? So that the mortgagor will pay higher. And then we have covenant to observe and perform any condition in the head lease. Now, this is usually applicable where the mortgage is created by assignment. When the mortgage is created by assignment, ownership, reversionary interest, everything has passed from the mortgagor to the mortgagee. So one of the disadvantages of this is that if there is any taxes, any rates, any levies that is usually paid on that property by the mortgagor, that obligation also passes to you, the mortgagee. You understand? So that is what this covenant is saying. So those conditions in the head lease, you have to perform them. The head lease is the lease between the holder of the certificate of occupancy and the governor. You understand? So if, for instance, the mortgagor was paying ground rent to the governor as the owner of the property, since he has passed both ownership and reversion to the mortgagee will start paying that ground rent to the governor. And then we have covenant to consolidate. Now, let me give you an example of what consolidation is. But grammatically, consolidation means to add things together. To consolidate means to bring things together. You understand? So imagine a situation whereby Chris uses his land at number 55 Ozuban, by the way, to take a loan from UBA. And then he uses another of his land at Odumosho to take a loan from the same UBA. And then he uses another of his land around Ikeja to take a loan. That is 3 different loans now from the same UBA. And then UBA is calling him, Chris, look, the legal due date for all these loans are so dates. They are so time. And then when that time reaches, Chris says he wants to discharge only the loan in Ikeja. UBA has the right to say, look, I don't want you to discharge one. You must discharge all of them together. If you want to pay for the loan, you must pay all of them together. That is what we call consolidation. You understand? So the mortgagee has the right to insist that the mortgagor cannot discharge one loan unless he discharges every loan that he has with him, the mortgagee. You understand? Every loan he has with him, the mortgagee. Consolidation is not lawful. So both parties must agree on consolidation. And then consolidation also has conditions as well. You understand? So it has to be the same mortgagor. It has to be the same mortgagee. It has to be different properties. It has to, the legal due dates for the different properties must have passed. You get it? Must have passed. And then parties must have agreed to consolidate without contrary intention. You get? And then lastly, if it's in Lagos, if the parties are in Lagos, a notice must be given to the registrar of deeds and title about the consolidation. And then there's something called covenant not to clog redemption. Sometimes in some principles, you will see something like once a mortgage, always a mortgage. Although that is not literally true, but theoretically it is true. You understand? So now, when you see covenant not to clog redemption now is the right of the mortgagor to pay his money and have his property reconveyed back to him. So the mortgagee cannot do anything. He cannot insert any condition or whatever clause. He cannot do any act or do anything that will prevent the mortgagor from redeeming his property. You understand? If he tries to do anything like that, then he's clogging redemption. He's not supposed to do that. For instance, you cannot be creating a mortgage and then you'll be telling the mortgagor that this is your property, you are going to redeem it only when me, the mortgagee, feels I have no use again of your property. It's not possible. By doing that, you are clogging redemption. You are slowing down his right to redemption. That is very, very wrong. Whenever the mortgagor has the full sum, the full mortgage loan, and any interest on it, he must be allowed to redeem his property. So now we talk about the right. Talk about the rights available to the parties to a mortgage transaction. We look at the rights of a mortgagor first. Now, the mortgagor has what we call equity of redemption. So this is just like what I've just been saying earlier. The mortgagor has what we call equity of redemption. So provided the mortgagor has his money, you understand? Provided he has his money, provided he has the interest, and he can pay you, the mortgagee, you must give him back his property. You cannot unduly hold over, you cannot unduly delay the mortgagor from redeeming his property. Any clause, any condition, any term in the mortgage agreement that is purporting to prevent the mortgagor from redeeming his property when he has the full amount of money to redeem same is invalid. You understand? A condition, a term, a clause cannot be stated in the mortgage agreement to prevent the mortgagor from redeeming his property. And but then it's relevant to know that this equity of redemption, these mortgagors of equity of redemption is not going to have any effect again. It's not going to have any effect again if a foreclosure order has become absolute. You understand? If, for instance, the mortgagee has applied to court, calling the mortgagor to redeem his property, and they gave him like 6 months, other nice side, and then after 6 months, it became absolute. You understand? After 6 months, it became absolute. In that case, he doesn't have equity of redemption again. Or where maybe the mortgagee has sold the property after the mortgagor defaulted in paying, his equity of redemption is lost. And then we have the legal right to redeem. Now, the legal right to redeem is the right of the mortgagor to redeem his property from that point when the mortgage transaction started to the period before the legal due date. The legal due date is like the deadline, understand? So from beginning of the mortgage transaction to before the deadline, understand? That is what we call legal right to redeem. So that period when the mortgage transaction was entered and then before the deadline, the mortgagor has legal right to redeem his property. And then there's what we call equitable rights to redeem. They say common law is harsh, but equity will come in to mitigate the hardship of common law. So in equity, for instance, even if the legal due date has passed, for instance, the legal due date is 10th August 2024. You understand? And then the mortgagor did not come on that 10th August 2024 to redeem his property. But then he waited until 14th of August 2024. Now, equity is saying that he can still redeem his property, even if the legal due date has passed, provided that property is still in your possession. It's still with you, the mortgagee, you understand? So the mortgagor can still redeem his property, on the basis of equity. On the basis of equity. And then we have what we call action in date anew. Action in date anew. So now this remedy is usually resorted to by the mortgagor, where after discharge of the mortgage loan, the title document is still retained by the mortgagee. So if the mortgagee doesn't want to give back to the mortgagor his title documents, such as his deed of assignment and other documents showing that he's the owner of the property, he can sue in date anew. And then if after paying the loan, the mortgagee doesn't want to convey back the property to him, he can still sue for specific performance of the contract that is compelling the mortgagee to convey back the property to him. And then we have the rights of the mortgagee. Now, what kind of rights does the mortgagee have? The mortgagee has a lot of rights. Understand? He has a lot of rights. Like you can see about 9 rights here: action in court, possession, foreclosure, sale, to appoint a receiver, specific performance. And then if the mortgagor, that is the person who borrowed the money, is a company, the mortgagee has the right to petition for winding up, to appoint a receiver manager, and then the pension holder's action. So these are all the rights of the mortgagee. So I would like us to note the following principles. An equitable mortgagee does not have the right to take possession. Understand? So an equitable mortgagee is excluded from the enjoyment of this right. An equitable mortgagee cannot appoint a receiver unless by the order of the court. And an equitable mortgagee cannot also sell. You understand? An equitable mortgagee cannot also sell unless the mortgage is made by deed and a remedial device is inserted to that effect. You understand? Unless the mortgage is made by deed and a remedial device is included in the mortgage. I believe by now I should not explain what remedial device means again. So we look at the first rights of the mortgagee, right of an action in court. You understand? So if the mortgagor has failed to pay the mortgage loan, the mortgagee can just take out an action in court, against him to recover his principal sum and any interest on the principal sum. And then the mortgagee can also decide to take possession of the property. Now, this is a remedy that does not come in consequence of any default, you understand? So even if the legal due date has not passed, even if the mortgagor has not defaulted in doing anything, you understand, the mortgagee can decide to take possession, you understand? So the legal due date does not need to pass. Remember, in a legal mortgage, you have transferred legal title over the land, you understand, to the mortgagee. You have transferred, you no longer have legal title over that property. So the mortgagee can come at any time to tell you, the mortgagor, to vacate, that he wants to use the property. You understand? So in this case now, legal due date doesn't need to pass. You don't need to do any default. It's a no-fault remedy. Understand? Although going into possession by the mortgagee is usually discouraged. You understand? And is discouraged because of the consequences. You understand? For instance, you have to, if you go into possession, you have to start paying the taxes, the rates, the outgoings, and you also have to render account. If you make any profit from being in possession, you also have to render account. You understand? You also have to render account. And then there's something called order of foreclosure. You understand? So a mortgagee can decide to apply to court for foreclosure. Now, the essence of foreclosure is to permanently and completely shut out the equity of redemption. Is to shut out the equity of redemption of the mortgagor. You understand? So in that case, they will usually call the person. If the mortgagee applies to court for foreclosure, that foreclosure order made by the court will usually be provisional, and then after 6 months it becomes absolute. You understand? Now, the effect of a foreclosure order becoming absolute in the case of a legal mortgage is that property automatically becomes its own. You understand? So in the case of a legal mortgage, once a foreclosure order has become absolute, that property automatically becomes the property of a legal mortgagee. You understand? Subject to any encumbrances, any higher interest on the property, but the property becomes its own. But then in the case of an equitable mortgagee, the property does not automatically become his own. You understand? So even when the foreclosure order has become absolute, the property does not automatically become his own. The mortgagor must have to convey the property to him. You understand? The mortgagor must have to convey the property to him. You understand? The mortgagor must have to convey the property to him. And then I want you to know that if, for instance, in the case of a legal mortgagee, that property has become his own, like I said before, by virtue of the foreclosure order becoming absolute, the property is now his own. Now, it is possible that a mortgagee a legal mortgagee can now decide to sell that property. You understand? If he decides to sell that property in order to recover the mortgage loan, maybe the mortgage loan is 5 million. Maybe the mortgage loan is 5 million. And then he now decides to sell the property, but he could only recover 4 million from the property. I want you to know that the mortgagee can still sue the mortgagor again. The mortgagee can still bring the mortgagor to court and sue him under the covenant, under the covenant to pay the principal sum and interest in order to enforce that covenant. Understand? So he wants to recover the remaining 1 million from the mortgagor. You understand? So this is possible. This is because the mortgagee has what we call a cumulative right. But now this right has a negative aspect. It has a consequence. And the consequence is that once you take a mortgagor to court to recover the principal sum and interest, after you have already gotten foreclosure order absolute and the property is now your own, and then you're still taking him to court again to recover maybe the remaining amount because the amount you sold the property could not give you the total amount of the loan. The negative aspect of this is that the mortgagor can now apply to reopen the foreclosure order. You understand? He's going to apply to have his equity of redemption resurrected. You understand? To have his equity of redemption to come into play again so that he can be able to redeem his property. Although during my time on campus, I was a little bit confused. I was asking my friend, how does a person reopen his equity of redemption over a property that has been sold? Is he going to go after the person that bought the property and all that you get? So if you see some case laws, you see it's quite funny. Listen, I've seen a case where they said that, yes, an equity of redemption can even be reopened against a third party who bought a property, provided that the mortgagor acts quickly, provided he acts quickly, it's possible. So it's somehow, so I'm wondering, who is now going to compensate the third party and all? So you can on your own do that research and listen very well. But I doubt if in class the lecturers are going to go this deep and all. They might just brush it on the surface and go their way. And then we are talking about reopening of foreclosure order. Yes, it's possible for a foreclosure order absolute to be reopened. You understand? It's possible for a foreclosure order absolute to be reopened. So even if a foreclosure order has been made absolute, the mortgagor can apply to court for it to be reopened. But there are certain things he must show. You understand? There are certain things he must show. For instance, he must show that the value of the property is far higher than the mortgage sum. You understand? Maybe the property is worth 50 million, but that the mortgage sum he collected from the bank is 20 million. Understand? And then he must also show that the property is of special value to him, the mortgagor. And then he must show that the grounds for reopening are just and equitable. And then that his inability to repay the loan, at the time they wanted him to repay was due to circumstances beyond his control. He now have the full amount of money to pay now. And then lastly, that after an order absolute, the bank still went ahead to commence an action against him, you understand, to recover the money. So he's now cashing in on this opportunity and filing an application for reopening. So now this is mainly what I was talking about. So you see that if you also reopen a foreclosure order absolute, he has to establish this to the court. He has to show the court this. And most importantly is the fact that that particular bank or that particular mortgagee, after an order absolute, after the foreclosure order absolute, probably they sold the property, they could not recover the full money, and they still went ahead to commence an action against him because they have a cumulative right as a mortgagee. You understand? So that is why he's now applying to the courts for the court to reopen his equity of redemption. So like I said before, a mortgagee has a cumulative right. He can sue under the covenant to recover the principal sum and interest when he sold the property and he could not recoup the mortgage loan he gave. But it has a negative aspect because the mortgagor will cash in on that opportunity and then we tell the court to open back his equity of redemption so that he can recover his property. And then the mortgagee also has what we call power of sale. We have been talking about this automatic power of sale. So immediately the mortgagor defaults. For instance, the legal due date is 10th August and the legal due date has passed and the mortgagor does not pay the sum. The mortgagee can just automatically sell the property. That is what we call power of sale. But two conditions must be fulfilled before the mortgagee can sell the property. One is that the power of sale must have arisen. Understand? The power of sale must have arisen. And then the second condition is that the power of sale must have become exercisable. And the power of sale is said to have arisen where the legal due date has passed, where the mortgage is created by deed, and there is no contrary intention preventing the property to be sold. You understand? So this is where you can see that the power of sale has arisen. And then the power of sale becomes exercisable depending on the state. In CA and PCL states, a 3 months notice must have been given to the mortgagor. And then that 3 months notice has expired and he has not taken any step to repay the money, you understand? Or where maybe the mortgagor has defaulted in paying the interest by way of installments, or when there's a breach of a term in the mortgage deed or law, you understand? So when a condition has been breached, I know. So if you notice very well, you will see that the power of sale being arisen is conjunctive. So these three conditions under being arisen is conjunctive. That is, the legal due date must have passed, it must be created by deed, and there must have been no contrary intention preventing the property to be sold. You understand? So these three must be in existence. And then for exercisability, one is enough. You understand? One is enough. One is enough. And then there's something I want to tell you. Oftentimes, immediately the power of sale has arisen, automatically it has also become exercisable. So it's not possible for you to say this power of sale has arisen, but it's not exercisable. Why? I'll tell you why. The answer is that immediately the legal due date has passed and the person did not pay the money, that automatically serves as a breach of a term in the mortgage deed, because in the mortgage deed it must have been agreed by the parties to pay the principal sum and interest within so time, and they stated the due date. You understand? It's a term, it's a condition in the deed of the legal mortgage. So if you don't pay it within that time and the legal due date passes, it's a breach of the term. You understand? So oftentimes, once the power of sale has arisen, it has automatically become exercisable as well, because they go hand in hand. And then I want you to know that there are instances where the sale of a mortgage property may be set aside. There are instances where the sale of a mortgage property may be set aside. So one of the instances is where, for instance, the mortgagor's title is defective. That is, the mortgagor was never the owner of the property. You understand? So a sale might be set aside in that case. And then if consent was not obtained, that is, a mortgage transaction itself is not even valid, it's void, because consent of the governor was not obtained, or where the mortgage transaction was not registered. You understand? Any sale of the property is invalid, or where there was fraud or collusion between the mortgagee and the buyer, or where the right of sale has neither arisen nor become exercisable. You understand? So imagine that the legal due date has not passed and the mortgagee went on to sell the property. That's bad. In that case, the sale will be set aside. That's the sale of the property will be set aside. And then where maybe the mortgagee sold the property after receiving full payment of their mortgage loan and so forth. And then there are also instances when a sale cannot be set aside. It is like an exception to what is stated above. You understand? So a sale cannot be set aside because court order was not obtained. There is no law that requires a person that requires a legal mortgagee to obtain a court order before he sells. It's not possible. Provided is a legal mortgagee, he has automatic right of sale. You understand? Unless he's in a CA state, in which case he will require a remedial device to be inserted where it is created by subdemise. You understand? So he doesn't need a court order. He's not an equitable mortgagee. He doesn't need a court order. And then because the property was sold at a low price is not a reason. It's not a reason why the sale of the property will be declared invalid. A low price is different from gross undervalue. You understand? It's different from gross undervalue. So the mortgagee should not sell at gross undervalue, but he can sell at a low price. Gross undervalue differs from a low price. You know, the mortgage property might worth 100 million. The mortgage loan is let me say 60 million. You understand? The mortgage loan is 60 million. And then the bank fees that selling this property for 60 million is, we help them recover their mortgage loan. 60 million and 100 million, you know, it's not that bad. It's low, but it's not gross undervalue. But imagine we had a bank sells a property for like 10 million. That is bad for a property that is worth 100 million. So you have to know the difference. And then that a demand notice was not given is also not a defense. It's not why they will have to set aside a sale, provided that the legal due date has passed. They don't need to give you demand notice. You know the legal due date yourself. And then that substantial payment has been made. You understand? So if, for instance, the mortgagor is owing like 50 million on the loan, and then maybe he has been paying small, or maybe he paid 40 million and then 10 million is remaining, and then legal due date passed, and the mortgagee sold the property. That sale is valid. You understand? It is not a defense that you have made substantial payment. It is not a defense at all. But then there are some precautionary measures. There are some precautionary measures that must be taken by a legal mortgagee to ensure that his sale of the property is not set aside, to ensure that the sale of the property is valid. For instance, he has to act in good faith. If the mortgagee is selling the property, he has to act in good faith. You understand? He must not sell to himself, his servants, his officers, or his agents. You understand? Otherwise, it might show the existence of collusion and fraud. He must not sell at gross undervalue. He might sell at a low price, but he should not sell at gross undervalue. And then we talk about the protection of innocent purchasers for value without notice. We saw something like this in the power of attorney transaction, how the law seeks to protect innocent third-party purchasers. Now, it is also here in a mortgage. Now, imagine if, for instance, a mortgagee goes ahead to sell a property to a third party. And then maybe when he sold that property, the power of sale has not arisen and the power of sale has not become exercisable. You understand? And he went ahead to sell that property to a third party. And that third party is a bona fide third party purchaser for value. He did not know. You understand? He acted in good faith and he did not have any notice that this sale of property is not valid in law, and he bought it and paid the full sum. You understand? Now, the law is saying that third-party purchaser for value is going to be protected, and then the mortgagee will have to compensate adequately the mortgagor. You understand? The mortgagee will have to adequately compensate the mortgagor for any loss suffered. You understand? For any loss suffered. But where it is shown, where it is established that third party is not really a bona fide third party purchaser for value, maybe he already had notice that the mortgagee was not supposed to sell that property, and the mortgagee then said, and he still went ahead to buy the property. So there's an element of bad faith in his action. There's an element of bad faith in the action of the third party. So he cannot be taken to be a bona fide third party purchaser for value. And then when a mortgage property is sold, this is how you apply the proceeds of the sale. You have to settle prior encumbrances first. So if there are prior mortgages, you have to settle it first. Remember what we did about successive legal mortgages. Remember what we did about successive legal mortgages. You have to settle the first one first, and then the subsequent one, just like that. So if a mortgage property is sold, you have to settle prior encumbrances. That is, if there's any prior mortgage, settle that one first, and then before you settle others. And then you have to pay costs and charges, including auctioneer's fees. You understand? Costs and charges incurred in the sale. including auctioneer's fee. And oftentimes it's auctioneers. Auctioneers will help in selling the mortgage property. And then you settle outstanding mortgage sum and interest. You settle outstanding mortgage sum and interest. That is to discharge the loan. You understand? You then discharge the loan, and then any balance is to be returned to the mortgagor. You understand? any balance at all, like any balance, any leftovers that is remaining, we have to return to the mortgagor. We have to return to the mortgagor. And then another remedy of the mortgagee is the right to appoint a receiver. Now, this is usually the case for companies. You understand? When a company is the mortgagor, when a company is the mortgagor, the mortgagee bank can decide to appoint a receiver. The purpose of a receiver oftentimes is to take control of a company, especially a receiver manager. To take control of the assets and business of a company, pilot the company very well, for the purpose of recovering the debt or the money of the people that appointed him. You understand? So a bank or a mortgagee can decide to appoint a receiver, to take charge of the affairs of the company, to pilot the business of the company and realize the money. That's a receiver manager. And then we have what we call additional facilities and off-stamping. I believe I've explained this before. Additional facilities and off-stamping. I've explained that before. So now we look at discharge of legal mortgage. So now, how do you discharge a legal mortgage? Now, how you discharge a legal mortgage will depend on the jurisdiction. Understand? It will depend on the jurisdiction and how the legal mortgage was created. So now, in Conveyancing Act jurisdiction, if you want to discharge a legal mortgage, you can use a deed of discharge or a deed of reconveyance, for your mortgage created by way of assignment. If the mortgage is created by way of assignment, a deed of reconveyance is more suitable. Understand? If the mortgage is created by way of assignment, you can use a deed of discharge, or more preferably a deed of reconveyance. Understand? Because you are conveying back the property back to the person. If the mortgage was created by subdemise in CS states, it is appropriate to use a deed of release or a deed of surrender. And then where the mortgage was created by way of a legal charge, like it's just a charge in CA states, you can use a mere receipt. You can just use a mere receipt to discharge the mortgage. And then in PCL states, if you want to discharge a legal mortgage, a statutory receipt, suffices for any mode at all, whether it is created by subdemise or by charge. Any mode at all, statutory receipt suffices. But then parties may still decide to discharge the mortgage by way of deed of release or a deed of surrender. You understand? Or by reassignment of transfer. All these are just modes that you can use to just discharge the mortgage. That is to say that this mortgage transaction is no longer in existence. This person has taken back its property. And then in Lagos, a statutory receipt can also be used. You understand? Although parties can still decide to use a deed of release, which is a registrable document. And then if the mortgage is an equitable mortgage, a simple receipt of payment underhand suffices. A simple receipt of payment underhand. You just write a receipt and then send it to say that the mortgage has been discharged. It suffices. But if you want to send that receipt to the mortgagee solicitor, if you want to discharge the mortgage, the equitable mortgage, through the mortgagee solicitor, it must be by deed. And then if a company is involved in a legal mortgage, a mortgage, in a mortgage where a company is involved, is usually registered as a charge against the company. It's usually registered as a charge against the company. So if you want to discharge a mortgage in which a company is involved, it is usually by certificate of discharge, a certificate of discharge and the filing of memorandum of satisfaction at the Corporate Affairs Commission. So that is usually the ways you discharge mortgages involving companies. You understand? So you can also see the draft for full sample of a deed of mortgage and memorize them as well.